We're scheduled for trial today. Come on forward, sir. Have a seat on that side, if you would, please. Are we going to have a trial today, Mr. Navarre, or were you able to work things out?
I haven't had an opportunity to talk to the defendant herein, but I have talked with my client. It's her understanding that the issues as it relates to custody, support, and parenting time have been resolved with the order that entered after meeting with the friend of the court, and is the order which is the current order of the court.
So is that correct, sir? The temporary order for custody, parenting time, child support is acceptable to you?
Yes.
So we could make that part of a permanent judgment of divorce?
Yes.
Okay, what else is there, Mr. Navarre?
Your Honor, there is a debt that is outstanding that was incurred in my client's name for the benefit of the defendant herein. And that was an auto loan, which she took out in her name. But he was supposed to make the payments. He was the one that had the vehicle. And there was a judgment that entered against my client by Marquez Auto Sales and Service. And that was decided in October of last year. And that was in the amount of $6,111.26 for non-payment of that installment loan. I think that there was an accident, the vehicle was totaled, and subsequent payments were not made. My client had to take a loan out in her name due to Solomon's status, and we would ask that at least he have a minimum responsibility of 50% of that outstanding debt. And that is out of Allen Superior Court, numeral 2, I believe in the state of Indiana. And it's docket number 02D02-1812-SC-018989. And again, that was decided on the 24th of October of last year. My client is the only one who's named as a party defendant to that. And that was a debt that was incurred for the benefit of the defendant.
So, sir, are you willing to be responsible for half of that debt?
Yes.
He's willing to do that, Mr. Navarre.
I believe that the personal property has been divided. Karen, are there any other issues that need to be addressed right now that the judge needs to know about?
No, not at the moment, no.
Okay. So that will cover everything, correct?
Yes.
Judge, if I may proceed, then I would like to have my client put on proofs to support the entry of a judgment of divorce.
Certainly. Ma'am, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
You can put your hand down. State your full name, please.
Karen Suzanne Zamudio.
Go ahead, Mr. Navarre.
And Karen, how do you spell your last name?
Zamudio.
And Karen, you signed a complaint for divorce in this matter. And when you signed that complaint, were the allegations true? And do they remain true today?
Yes.
Are you currently pregnant?
No.
Has there been a breakdown in your marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Correct.
Are you seeking entry of an absolute judgment of divorce?
Yes.
And you and your husband Solomon have previously divided personal property, is that correct?
Yes.
And you and your husband own no real property or real estate on your own or together, is that correct?
Yes.
So there's no real estate that needs to be divided, just personal property, and you've already done that. Is that correct?
Yes.
Is that division fair and equitable as far as you believe?
I believe so.
Okay. And you heard what the court was willing to do, or as it relates to this outstanding debt for the vehicle with this small claims judgment in Indiana, that you and Solomon are both going to be responsible for 50% of that, and that would go into the judgment of divorce. Is that acceptable to you?
Yes.
Thank you, Your Honor. I have no further questions of the witness, and I would move for entry of an absolute judgment of divorce. I will submit that as Your Honor directs, and I would indicate to the parties that they're not divorced today, that they won't be divorced until the paperwork is signed and approved and entered by the court. Solomon, if I send that paperwork to you or provide it to Karen, can you sign that paperwork if it reflects what the court has ordered today and what is currently in order through the temporary order through the friend of the court through the conciliation process?
Yes.
Okay, I think we kind of have the basis of a consent agreement on the record, but I'm just going to clarify to make sure there's no problem. So, Mr. Zamudio Morektajo, okay. You are in agreement that the provisions of the temporary order regarding custody, parenting time, and child support previously entered in this file become a part of your permanent judgment of divorce?
Yes, I just had the same question that I had before, that he was gonna speak to Karen about 5 months that the kids had spent at my mom's house. With her only seeing her, the kids 3 times. My other concern was that she left to go to UP the Friday after we had last court, and left the kids by themselves since 5 o'clock in the morning. I do have a police report that about that.
So I cannot address that specific issue today. All I can say is the terms of this temporary order will become part of the permanent judgment, and I expect you both to abide by it. You're willing to abide by it?
Yes.
And you want her to abide by it?
Yes.
Okay. Does that address your concern?
Yes.
Okay. Can you confirm to me that you are not seeking any spousal support?
No.
And you agree that it should be forever barred?
Yep.
You are not seeking any right on your own behalf in any policies or contracts of life insurance, endowments or annuities on the life of your wife? You're willing to extinguish those if they exist. You're not seeking any interest in any pension, retirement plan, retirement savings that your wife has? And you're willing that any of the such right that you might have in those things be extinguished by a judgment of divorce? You agree that you've already divided your personal property? You agree that you don't own any real estate?
Yes.
And you agree that you're going to be 50% responsible for the small claims judgment, or from the judgment that arose from this non-payment of a vehicle obligation?
Yes.
All right, typically that will include language that says if she has to pay any of your half, you're going to indemnify and hold her harmless for anything she has to pay over that 50% amount. You understand that?
Yep.
And you're okay with that provision?
Yes.
That will be mutual.
Your Honor, as it relates to that provision, I standardly incorporate language that indicates that if she's required to pay or he fails to pay, or vice versa, that the non-defaulting party would be entitled to spousal support, which would be non-dischargeable in bankruptcy. But other than that, my
But spousal support,
a statutory right to that.
spousal support in the net amount, or gross amount rather, of whatever either one has to incur because the other failed to abide by the obligations of the judgment?
That's correct, Your Honor. And given
Okay.
the change in law under the Tax Cut and Jobs Act, it's non-deductible and non-includable. So that's a non-issue as it relates to net or gross.
All right, so I want to make sure you understand that. The provision he's going to put in basically says if you or she fail to pay your half of that obligation, that the obligation will be converted essentially to an amount of spousal support equal to the amount that you didn't pay. And the reason for that is to make sure you can't discharge it in bankruptcy.
Right now, I have full issue paying
Okay.
what needs to be paid.
All right, I think we have a full agreement on the record that the court would be able to enforce. I expect if you get a form of judgment from Mr. Navarre that reflects everything we put on the record, just sign it and send it back to him, and as soon as I get that back, you will be divorced.
All right, thank you.
Your Honor,
Okay, any other questions?
If I may, Your Honor, inquire of my client as it relates to the further inquiry that you had of Mr. Zamudio Morektajo.
Certainly, go right ahead.
Karen, you heard what the judge asked Solomon, correct?
Yes.
And your answers would all be identical to his answers, is that correct?
Yes.
If you're willing to have these additional provisions put in, which are pretty much standard provisions that would be in a judgment of divorce, you're willing to live up to and abide by and follow those orders of the court that are going to be contained in the judgment of divorce. Is that correct?
Yes.
And I want to ask you that, you know that you have the right to go to trial today and that your husband has been defaulted, but that you feel that the agreement that you've reached, the parenting time and custody and support that is outlined in the temporary order is in the best interests of the kids and also is fair and equitable. And that's something that you are willing to accept, adopt, and follow. Is that correct?
Yes.
Did you understand that you could have done better if we actually had a trial? Do you understand that you may have come out better from a property standpoint or otherwise if we had a
No.
trial?
No.
Okay. You understand that you might have done worse if we had a trial?
No.
Okay. You have the option to go forward with the trial, but do you feel that this is fair and equitable and in the best interest of the children to settle the matter on the terms that have been put on the record today?
Yes.
And you satisfied with my assistance of you in this matter as your attorney?
Yes.
I have no further questions, Your Honor.
Thank you. I do find that there's been a breakdown in this marriage to the extent the objects of matrimony have been destroyed. There remains no reasonable likelihood that the marriage can be preserved. I will sign that consent judgment of divorce upon presentment. We'll set a status conference in 28 days. As long as the judgment is in before that time, there will be no need to appear.
Judge, I have one more thing I'd like to state on the record today, if I may briefly, and that is that there was a period of time this past summer that the children were in the care of their grandparents. And that was because of concerns that my client has as a frontline hospital worker for Henry Ford Allegiance Health. She works in the COVID tent, Your Honor. And so initially she was concerned about transmission to the children. And so for purposes of safety, protection, during this COVID-19 pandemic, she felt that it furthered the children's best interest for them to primarily be with the grandparents for a significant amount of time over the past several months. And so that was the reason for that, but that is not the situation now. The children were residing for the summertime significantly with the grandparents in Morenci, Michigan. Mr. Zamudio Morektajo resides in the Marshall area. My client's here in Napoleon, where the children are in school. And so I wanted to put that on the record to indicate that that was a parental decision that was made to further the kids' best interest. And with that, I will conclude and close the record.
Okay, thank you very much. That concludes our hearing. Have a good day, sir.
Thank you, Your Honor. Karen, I'll give you a call.
Thank you.